All right, let's talk about the Town and Country Planning Act 1990. I know, it sounds like something you'd leave to the planning department, right? But what if I told you it's not just a rule book for them? What if it's one of the most powerful, proactive tools in your toolkit as an environmental health officer? Today, we're going to open it up and see how you can use it.
And look, I get it. You're out there on the front line, day in, day out, dealing with noise, smells, and all sorts of public health complaints. So you're probably wondering, how on earth can a law from over 30 years ago be one of your best weapons in 2024? Well, that's exactly what we're here to figure out. How to use this act to stop problems before they even become a complaint on your desk.
So, first things first, let's look at the blueprint of the whole system. The entire world of planning control and your ability to have a say in it really boils down to one single foundational idea. And if you get this concept, you've pretty much got the key that unlocks everything else.
And that big idea is development. Now, the Act's definition here is incredibly broad. We're not just talking about new houses. For you, the really critical part is material changes in the use of land. Think about it. That quiet warehouse on the edge of town? Someone wants to turn it into a late-night takeaway? Yep, that's development. A factory wants to install a new, much noisier piece of machinery? That's development too. This right here, this is your official invitation to the party, your entry point to get involved before a potential nuisance ever sees the light of.
Okay, so we know what the Act actually controls. Now for the good stuff, the levers you can actually pull. This is where we go from just spotting a potential issue to actively shaping and managing it. And we do that through planning permission and, crucially, planning conditions.
And this is where it gets really interesting. A standard permission is just a simple green light. A yes, but permission with conditions? That's your territory. That's what turns a simple yes into a yes, but only if. And this is exactly where your expert knowledge as an EHO is vital. You're the one who can suggest legally sound conditions to control noise levels, limit operating hours, manage waste disposal, or even demand contamination reports. It's literally how you build public health protection right into the DNA of a project.
And don't worry, this power isn't just some vague idea. It's written right into the law in Section 72 of the Act. I mean, look at these examples. You can get a condition that requires a noisy operation to stop after a certain date. You can demand that temporary buildings for construction site are completely removed once the project is done. And you can make sure the land is put back to how it was. This is how you ensure a short-term problem doesn't become a long-term nightmare for residents. So, we've planned ahead, we've set conditions, but what happens when the rules get broken anyway? What if a developer just ignores those carefully thought out conditions? Well, that brings us to the third tool in our kit, the hammer. These are your enforcement powers, and trust me, they have some serious teeth. Now, you don't always go in swinging the hammer right away. The first step is often finding out exactly what's going on. That's where the planning contravention notice comes in. Think of it as your official detective tool. It's a formal, legally binding request for information. So if you suspect that new garage is actually running a noisy, unauthorized repair shop, this notice forces the owner to tell you exactly what they're doing on that land. It's your way of gathering the evidence you need. Right, once you've confirmed there's a breach, the main tool is the enforcement notice. And let's be clear, this is not a suggestion, it is a legal order. And as you can see, it has to be absolutely crystal clear. You have to state exactly what the breach is, spell out precisely what steps they need to take to fix it, and give them a firm deadline. There's no room for guesswork. And here it is. This is the line that gives the notice its real weight. Section 179 makes ignoring an enforcement notice a criminal offense. But pay close attention to who is responsible, the person who is then the owner of the land. This is so important. The notice attaches to the land, not the person. It means they can't just sell the property and make it the next person's problem. The problem stays with the land until it's fixed. Okay, we've talked about the blueprint, the levers, and the hammer. So let's just pull this all together. Why should this 30-something-year-old act be a core part of your day-to-day EHO toolkit in 2024? Well, this really sums it up. The Act lets you anticipate problems by getting your voice heard early on during planning applications. It gives you the power to influence the outcome by shaping those legally binding conditions. It gives you the legal framework to partner effectively with your planning enforcement colleagues when there's a breach. And what does that all add up to? It means you can protect your community. It shifts your role from just being a reactive firefighter to being a proactive guardian of community health. So I'll leave you with this final thought. The Town and Country Planning Act isn't just a document for planners. It's a shared resource, a powerful tool for both of you. So the real question to take back to the office is this. How strong is that link between your environmental health team and your planning department? Is it a well-oiled machine? Or maybe, could it be even stronger? Because a stronger partnership there, well, that means a healthier, safer environment for everyone you serve.